People ask questions about wills and estates. The first question is usually, what is a will and why do I need one? Every adult should have a will. As you accumulate assets, it's a good idea to make sure that they pass to the people you want them to. If you don't have a will, an intestacy occurs, and then your assets may pass to people you don't want them to. Will also provides you with the opportunity to name guardians for your children, establish a trust, or donate to charity. Another question is, what is an executor? Executor is the person you appoint in your will to administer your estate. Usually this person is your spouse, de facto partner, a close friend or family member. You can have more than one executor. Sometimes people appoint a professional, such as a solicitor or an accountant or professional trustee company. We can speak to you about who is the appropriate person for you. People also ask, who sells the estate property? The executor consults with the beneficiaries and seeks their instructions about the sale of the property. Beneficiaries may take the transfer of the property, or they may request the executor sell the property at auction. In some instances, though, the deceased may have set out in their will that they require the sale of assets prior to distribution to the beneficiaries. Executors may also need to apply for probate of the will before funds in the estate can be accessed or distributed. People ask, what is the difference between assets held jointly or as tenants in common? Jointly owned assets don't form part of your estate. They pass by survivorship to the surviving spouse or co-owner. Assets held by you as tenants in common pass under your will to your named beneficiaries. People ask, where should I keep my will? The will should be kept in a safe place. We offer a free storage service to our clients and recommend that our clients leave their original will in our fireproof safe and to tell someone that you've done so. People often ask, how often should my will be revised or updated? Making or altering a will is particularly important when life or circumstances change. It's a good idea to review your will every 3 to 5 years to ensure that it reflects your wishes. You definitely need to review or possibly change your will if you get married, divorced or separate, or enter a de facto relationship, children or grandchildren are born, beneficiary dies, your executor dies, or there's a change in your financial circumstances. People ask, what happens to any debts I have when I die? Funeral and estate administration costs must be paid first. All other debts are then paid. Then the distribution of the remaining estate can be made. If there isn't enough money to pay the estate debts, they have to be paid proportionally from all available funds. Debts are not passed on to the families or to beneficiaries. People are always interested in, who can contest my will? A spouse, a de facto child, biological, stepchild or adopted, or a person financially dependent on the deceased may challenge a will. People ask, can people contest my will if I leave them a bequest in my will? Yes, they may still have the right to contest your will if they feel they are entitled to a larger share of the estate. These disputes often require an application to the Supreme or District Court for determination. Civic matters must be proved for applications to succeed. People ask, will getting married or divorced affect my will? Your will is revoked or cancelled if you get married, unless your will specifically states that it's made in contemplation of marriage. Divorce revokes any provisions in your will in favour of your former spouse, including appointments as executor or guardian, but other provisions, for example, for children, may still apply.